In this lesson, we will begin our discussion on the concept surrounding the constitution of the company, namely that of dealing with insiders. Now, up until this point, if you look at every single lesson that we've come across, from the very incorporation process to the regulations that have been in place, by and large, we considered this on two different fronts. On the one hand, by considering the company itself as its own legal personality, and on the other hand, by virtue of the parties that are tangent to it, in other words, the shareholders and the management, in this case, the directors. Similarly, from this lesson onwards, we will dive deeper into the relationships that are built between the now incorporated company as well as its membership, those who are tangent or connected to the operations of it. By and large, we can separate these two into constitution and membership. On the one hand, when we consider, or what we consider as constitution, is in fact the actual rules governing the company and its very makeup, the nature of how it operates. This is governed primarily by virtue of the Articles of Association, something we've touched on briefly in a previous lesson, but we will dive deeper into in this lesson and the next. On the other hand, you have membership, essentially the people that are involved in the operation of this particular company, as well as anyone that stands to gain from the company succeeding. In other words, shareholders. Now, collectively, it must be understood that the constitution, the very company, and its membership, which is required for its operation, is considered as the company at large. Now, having said that, the very first aspect then that we must consider is the constitution. What is the company in itself? How does it operate? What its makeup is like, and so on. So, firstly, we have to consider the concepts surrounding the Articles of Association, essentially the rule book by which the company operates itself. On the one hand, you have the shareholders, the board, and the very makeup of the company as defined by the articles. Moreover, you have the notion that this particular document, this Articles of Association, is in effect a constitution. It's the set of rules that governs everything. And because of that, and because these are entities which are formed between parties, the parties themselves are essentially free to create their own Articles of Association. But having said that, more often than not, companies actually prefer to implement what are known as model Articles of Association. This is essentially, by and large, what Parliament has essentially enforced or passed as being the type of articles which are essentially legal without many loopholes being in place. So these model articles can be incorporated or taken into as a template and then edited according to the specific requirements of this particular company based on the business that it's related to. Now, where we see these model articles is not in fact in the Companies Act of 2006, but rather in the Companies Model Articles Regulations of 2008. Essentially, this set of model articles, or the governing principles, so to speak, in fact governs that of private and public companies and provides essentially the powers of the board of directors and what exactly happens during a general meeting. On the one hand, what is known as the management organ, and on the other, that of the members organ. So we will look at each of these aspects in detail as we go along. But firstly, we must understand what in essence the model articles entail. Basically, the model articles outline how exactly the general meeting is supposed to happen, how shares and distributions of such shares are to take place, what decision-making methods are to be adopted, the actual directors' powers and responsibilities, and most importantly, the management power of the board and how exactly appointments and removals are to take place. So let's take one at a time. When it comes to the management power of the board, we see in Howard Smith Limited and Ample Petroleum Limited that a board is to be empowered to run the company, And the primary power-wielding organ of the company is the said board. And we see this in the model articles as well. The powers conferred on the board, the directors, is absolute. On the other hand, the model articles, quite interestingly, only provide for the removal of such directors off a board in relation to some sort of incapacity which might have taken place or on the own volition of the director, in other words, by virtue of resignation. When you have to look at a direct removal process, you have to refer to Section 168 of the Companies Act of 2006. Now, mind you, I cannot stress enough that these are model articles. Essentially, this is a template provided by statute in order to follow. There is no essential rationale besides the fact that this is a tried and tested method other than to use it. Companies are completely free to incorporate whatever articles they want. It's just that these model articles is what has been found by law to be the easiest way in without having much issues in terms of the rights and responsibilities of the parties involved in the company. Now, having said that, the fundamental powers that a shareholder or a member has, as opposed to what the directors have in terms of running the company, can be set out and activated during a general meeting. And this is quite important to understand because the powers of the shareholder are only activated during a general meeting. We see this as outlined in Section 336 of the Public Companies and Traded Companies AGM provision within the Companies Act of 2006. Essentially, when it comes to a public limited company, having an annual general meeting or an AGM is essential. It's a must. Whereas a private company, it's not so necessary. Once again, it goes back to that original principle that when it comes to a PLC or a public limited company, you're dealing with the public at large and the public funds. And there are certain regulatory restrictions that you wouldn't find in private limited companies, which are there in PLCs. But what's important to understand at this juncture is what powers are actually conferred on the shareholders when it comes to these general meetings. While each company will have its own distinct set of powers, generally, it'll provide an opportunity for shareholders to vote on the appointment and removal of directors, the issuance of shares, altering of the articles in some instances, with obviously a much more stringent regulation such as a 3/4 majority in the board, as well as a special resolution. Having said that, what's important to understand here is that the process by which the shareholder operates is quite democratic. In other words, we will look at this later on in our lessons as well in this course, but by and large, the principle that is adopted within this context is that majority shares rule. But at this juncture, just remember that when it comes to a general meeting, it is only during the general meeting that a shareholder has an opportunity to firstly voice his or her opinion and secondly be able to vote on important matters pertaining to the company. That was a quick introduction on dealing with insiders, specifically considering the distinction between the constitution as well as membership and how it forms the company at large. In the next lesson, we will look at the other component that we considered at the very inception of this lesson, which is membership.